A very good evening to all of you. Hello and welcome, guys. My name is KP Singh and I welcome one and all to 39th episode of Fortnightly Law School. For those of you who are attending this session for the very first time, I will briefly introduce you to what we do here. In Fortnightly Law School, we will cover all the important legal news items from past couple of weeks. So if you have missed out on reading newspaper or you're preparing for law entrance exam, this session is going to be of great use. So get ready with your notepad and pen. Feel free to ask as many questions as you like. And if you want me to cover any particular topic in upcoming sessions, you can always leave a comment when the live stream ends. So welcome everyone. Usually we conduct Fortnightly Law Scoop on Saturdays, but due to some issue we couldn't do it yesterday, so we are conducting this session today. Well, in order to select the best quality, just click on the settings tab and pick the best option available on your system. Can someone quickly confirm if the audio is fine and all of you can see the screen? Welcome Vishwajit, welcome Riddhi. Okay, thank you so much Riddhi for the confirmation. Okay, moving on. Well guys, if you haven't started preparing for law entrance exam, I would suggest you to check out the Zero Fear program available at imsindia.com. It will give you a glimpse into law school preparation journey. If you want one-to-one mentoring, you can get in touch with your nearby IMS center. The first issue is related to the issue of marital rape. Are you guys aware that marital rape is not considered equivalent to rape in our country? Yes, that sounds so unjust, but it's true. So section 375 of the Indian Penal Code 1860, which defines rape, provides an exception for the husbands if they are committing rape against their wife, provided that she is not under 15 years of age. So how hilarious, or you can say how cruel is that? Recently, the Supreme Court bench comprising of Justice Ajay Rastogi and Justice B.V. Nagaratna issued a notice to a batch of petitions filed assailing the split verdict of Delhi High Court on the issue of marital rape. So, on 11th of May, Delhi High Court Division Bench gave a split judgment. Split judgment means when there are only two judges and both of them have opposing opinions. So, it is only possible in cases of division bench. I hope you guys are aware of bench system in our country. So if we say there's a single bench, that means only one judge was hearing that matter. If we call it a division bench, that means two judges would be there. So division bench is also called double bench. If I say full bench, that means three judges were there. But whenever we use word constitutional bench, that implies five or more judges in odd numbers. And whenever we constitute constitutional bench, Chief Justice of India will also be part of it. So a division bench of Delhi High Court recently gave a split judgment on the issue of marital rape. Justice C. Harishankar and Justice Rajiv Shabdher were pronouncing a judgment, and both of them disagreed regarding validity of the exception to section 375 in Indian Penal Code. This exception exempts forceful sexual intercourse by a man with his own wife from the offense of rape. So moving on. The title of the case was Writ Foundation versus Union of India and other connected matters. So this question has been raised up in many cases related to rape. Section 375 has many other flaws, not just this. So if you look at the bare text of section 375, I want all of you to just go through it once, just read it, the text on your screen, and try to give me couple of criticism of the drafting of this provision. इसमें क्या कमियां नजर आती है आपको, आपके सामने स्क्रीन पर है. So what is rape as per section 375? A man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman under circumstances falling under any of the six following descriptions. So देखिए पहला flaw आपको first line में ही मिल जाता है. What is the problem with this definition? This definition is not gender neutral, as you can see. So as per section 379, rapist can only be a male. Only a man can commit rape. A man is said to commit rape. This is the starting line, right? And rape victim can only be a woman. Read second line. It says sexual intercourse with a woman. So if a guy rapes another guy, that will not fall under section 375. If a girl rapes a girl, that will also not fall under section 375. If a girl rapes a guy, even that will not fall under section 375. So it is a very heterosexual conservative definition of rape, which is a punishable offense under section 375. Okay, so these are 6 conditions. First one being it should be against the will, or it should be against her consent. Thirdly, if the consent has been taken by putting someone, either the victim or someone else, in fear of death or hurt. Fourthly, if consent was taken through fraud, that means you make her believe that you are her husband, or consent was taken by administering some intoxicant or stupefying substance. And sixthly, if it is with or without consent when she is under 16 years of age. 16. Well guys, this was changed to 18 by the Criminal Law Amendment Act of 2013. So any kind of sexual intercourse with a person who is under 18 years of age is considered rape, right? So even if your physical relation is consensual, it will amount to rape under section 375 if the girl is under 18 years of age. But if you two happen to be husband and wife, Palika Vadhu, and your wife is not under 15 years of age, then it will not amount to rape even if there is no consent involved. So ऐसी बहुत सारी कमियां हैं इस डेफिनेशन में, इस वजह से ही आईपीसी के सेक्शन 375 को कई बार क्रिटिसाइज किया जाता है. Sexual intercourse by a man with a woman without her consent is rape. In short, this word rape comes from a Latin term rapio, which means to seize. And therefore, it means sexual intercourse without the consent of the lady, either by force or fear or fraud. In Fool Singh versus State of Haryana, Supreme Court has laid down a simple definition. It means rape is a violation of private person of a woman. It is an outrage by all canons. Okay, so explanation says that penetration is sufficient to constitute sexual intercourse necessary to the offense of rape. It need not be penetration through your sexual organs. It can also be through your digits. Recently, a case was highlighted when a 70 or 60-year-old guy digitally raped a 2-year-old girl. Right? So even that will be considered rape, because all other factors have been fulfilled. So rapist is a guy, victim is a girl, and it is against her will without her consent. Look at the exception, the last line on your screen. It says sexual intercourse by a man with his own wife, the wife not being under 15 years of age, is not rape. So different high courts have difference of opinion on this point, and therefore this particular case at the Supreme Court. So what happened at the High Court was that Justice Rajiv Shakdher said that exemption of the husband from the offense of marital rape is unconstitutional. Which right do you think it is violating? So which fundamental right do you think this exception is violating? It is violating many rights, but most importantly, it is violating Article 14. Article 14 stands for? Well guys, Article 14 talks about right to equality. So Justice Shakdher says that it is against right to equality. So Justice Hari Shankar, who was the co-panelist in that judgment, disagreed. He said that the differentiation is based on some intelligible differentia, and therefore the exemption does not violate the Constitution. So Article 14 talks about equality before law and equal protection of law. Equality before law means everyone shall be treated in the eyes of law. Everyone shall be treated in the eyes of law. Everyone is equal in the eyes of law. अब इसको ऐसे समझिए कि if government wants to treat two different peoples differently, then it will have to provide some intelligible differentia, some logical point of differentiation between these two groups. If government can provide intelligible differential, it can treat different sections of society differently. So look at reservation system, look at beneficial or provisions helping out any backward segment of society. So there are separate rules for senior citizens, there are separate rules for physically disabled people. So what about this exception? It says if your wife is above 15 years of age, then even if physical relationship is without consent, it will not amount to rape. Is there valid classification? What is the classification? Age? How is consent of a 15-year-old or 16-year-old girl different from a consent of a 14-year-old girl? So if your wife happens to be under 15, then it will amount to rape. If she happens to be above 15, then it will not amount to rape. If two people are not married and their physical relationship, even if it is with consent, amounts to rape if the girl is under 18 years of age. So just look at the paradoxical situation that law puts you in, and that's the reason it is being challenged. Riddhi says minors cannot consent. That's correct, and therefore any physical relation with a person who is under 18 years of age will amount to rape. So if the girl's age is under 18, it amounts to rape, except when physical relationship is by the husband and the girl is above 15. So if your wife is above 15, even if she is under 18, her consent will not matter. So because of this, Supreme Court has decided to hear this matter out. This matter has been referred to a larger bench. The court has agreed to hear the issue in the month of Feb next year and clubbed all the matters regarding this issue of marital rape pending in the Supreme Court together. So we are looking at some landmark judgment in the month of Feb on the issue of marital rape. I hope this much is clear. Let's move on to another news item. Supreme Court indicated that the issue of accessibility has now been addressed by the video conferencing mechanism. So, recently an NGO called Lok Pehri approached the Supreme Court of India claiming that Article 130 of the Indian Constitution should be put into operation. That means it should be put to good use. What is Article 130? Article 130 of the Constitution says that the Supreme Court of India shall sit in Delhi or in such other place or places as the Chief Justice of India may, with approval of the President, from time to time appoint. How many Supreme Courts do we have in our country? There's just one. And how many judges can be there at the Supreme Court of India? As per Article 124, there can be 33 plus 1 judges. So plus 1 we use for the Chief Justice of India. So there's only one Supreme Court, and there are just 34 judges in total, and we have a country with a population of around 130 crore people. Article 32 of the Indian Constitution gives us a fundamental right to directly approach the Supreme Court of India if your fundamental right gets violated. But do you think if somebody is living in Guwahati, or somebody is staying in Jaisalmer, or somebody is staying in, let's say, Trichy, would it be a good idea for them to go to the Supreme Court of India at Delhi? Isn't it unfair for people belonging to remote parts of our country that the Supreme Court happens to be in the northern part of our country and not at some central location? Well, Supreme Court is not just a place, it is the judges. If the judges decide they want to sit at Bhopal from tomorrow onwards, they can do so. That is the power under Article 130. So, Lok Pehri NGO is claiming that government or the Supreme Court should direct the government to create regional benches of the Supreme Court. It is not just the government or the NGO, rather even Law Commission reports have recommended something similar. So the report that they are relying on is the 229th Law Commission report, which suggested that there should be at least a regional bench of Supreme Court at all the metropolitan areas, or you can say the big metro cities of a country, places like Kolkata, Mumbai, Chennai, Bangalore and others. Or what do you think, what is your opinion, guys? Shall we shift Supreme Court to a more centrally located place? Don't you think Bhopal के आसपास कहीं होना चाहिए, so that everybody can reach easily? Well, चलिए, so setting up of regional benches of Supreme Court is the discretion of Chief Justice of India. Justice कोहली ने डांटते हुए ये भी कहा था, petitioner say that what is your right under Article 130? 130 does not give right to people of India, it gives right to the Supreme Court Chief Justice. So if we go back, read what Article 130 says. Supreme Court shall sit in Delhi or such other place or places as the Chief Justice of India may appoint, obviously with the approval of the President. So it is discretion of the CJI, not the petitioner, to decide कि Supreme Court कहाँ बैठेगा, right? So setting up regional benches is CJI's prerogative. If he or she wants, he can do it. And on the issue of accessibility, now court has a new answer to that. Now court says that we have VC. VC is virtual hearing, video conferencing. So we now have counsels logging in from all parts of the country, from their offices and homes, stated Justice Rahima Kohli. And Ms. Kohli also said that petitioner is relying on 229th Law Commission report, which came out in 2009. 12 years later, technology has changed. 12 years back, it wasn't possible to conduct virtual hearings in a safe and secure manner. Now it is being done thanks to COVID. You can say necessity is the mother of invention. Now people got used to it, and virtual conferencing is a big part of hearings, day-to-day hearings at the apex court of a country. And therefore, we don't need to open up new benches. Rather, we should allow more VCs or virtual video conferencing to happen, right? That is going to solve the problem. Chale, so I hope everybody understood what was the issue here and why it got rejected. So the earlier 229th report of Law Commission stated that we need to increase accessibility of justice, especially the appellate jurisdiction of the Supreme Court. Article 32 will not be properly utilized to its fullest if there are if we don't start up new benches of Supreme Court in all parts of a country. Now, court says that there is no need to do that. Why? Because we can do it virtually. Chale, next question. Tirumurthy Fragrances Limited versus Government of NCT of Delhi. A very important issue. Let's see how many of you can answer this one. What is a precedent? Precedent क्या होता है? Doctrine of precedent is something that a country follows. Rather, all common law countries follow doctrine of precedent. Okay, let's say. So, precedent basically means that once a matter has been decided by a competent court, it shall be used as a binding example in all future similar cases. A thing adjudged shall be used in all future similar cases. Doctrine of precedent works in two ways. A higher court judgment will always be binding on the lower court, and a larger bench judgment will always be binding on the smaller bench. So, Supreme Court of India's verdict is binding for all the high courts. That means all high courts will have to follow that interpretation. It is also binding on all the lower courts, but a 3-judge bench Supreme Court judgment is binding on a 2-judge bench judgment. Like Keshwaranand Bharati judgment, India's largest bench was 13-judge bench judgment. It overruled 11-judge bench judgment of Golaknath. IC Golaknath versus State of Punjab was an 11-judge bench judgment, and Keshwaranand Bharati was a 13-judge bench judgment. Now here's a question for you. A single bench, or let's say a division bench judgment of Supreme Court, will it be binding on a full judge bench of High Court? That means Supreme Court के 2 जजेस का फैसला क्या High Court के 3 जजेस के फैसले पे भारी पड़ेगा? A simple yes or no would do. Okay, let's see. Well guys, answer to this question should be yes. So higher court judgment is always binding on the lower court. Higher court verdict has more value. Okay, look at the question on the screen. A 7-judge bench delivered a judgment with 4:3 majority. On the other end, a 5-judge bench delivered a unanimous judgment. Which one do you think shall prevail? तो एक 7 जज बेंच का जजमेंट है जो 4:3 की मेजोरिटी से डिलीवर किया गया. दैट मींस 4 जजेस अग्रीड ऑन वन साइड and 3 were against it. So majority judgment was written by 4 judges. Compare that with a 5 judge bench judgment in which all 5 judges agreed. Which one do you think shall have more authority? Which one will be considered superior? 5 judges का unanimous फैसला या 7 judge bench में 4 judges का majority decision? So you will say that 7 judge bench will prevail, and yes, you are right. Okay, so right answer here should be obviously 7 judge bench judgment, thanks to Article 145 of Indian Constitution. So recently a 5 judge bench comprising of Justice Indira Banerjee, Hemant Gupta, Suryakant, M.M. Sundaresh and Sudhanshu Dhulia gave this ruling that a judgment delivered by a larger bench will prevail irrespective of the number of judges constituting the majority. So 7 judge bench का 4 judges का फैसला 5 judge bench के unanimous judgment के ऊपर भारी पड़ेगा. So bench pointed out that under Article 145 Clause 5, the concurrence of the majority judges is viewed as judgment of the court. यानी 4 judges का ये फैसला 4 judges का ना मान के 7 judges का फैसला माना जाता है और इसीलिए ये 7 जज बेंच जजमेंट है. सो ये प्रॉब्लम कहां से राइज हुआ, ये क्वेश्चन कहां से आया? पहले भी बहुत सारे जजमेंट्स में ये क्वेश्चन पोज किया गया है. सो द सेम इशू वाज आंसर्ड बाय जस्टिस नागेश्वर राव इन जयश्री पाटिल केस, पॉपुलरली कॉल्ड मराठा कोटा केस, एंड दिस इशू वाज रिसेंटली रेफर्ड बाय अ 2 जज bench comprising of Justice Nariman and Justice Sanjay Kishan Kaul in 2017. They stated that if a unanimous 5 judge bench decision is overruled by a 7 judge bench with 4 learned judges speaking for the majority and 3 learned judges speaking for the minority, can it be said that the 5 judge bench has been overruled? Under the present practice, it is clear that the view of 4 learned judges speaking for the majority will prevail over unanimous 5 judge bench decision because they happen to speak for 7 judge bench. Now, after observing this, they raise the question, has the time come to tear the judicial veil and hold in reality a view of 5 learned judges cannot be overruled by a view of 4 learned judges speaking for a bench of 7 learned judges? This is a question which also needs to be addressed and answered, right? So Justice Sanjay Kishan Kaul and Justice Nariman ने ये सवाल उठाया था कि देखिए मान लिया कि rules and regulation बताते हैं bigger bench should prevail, but don't we need to look behind the veil? हमें पर्दा उठा के नहीं देखना चाहिए कि एक तरफ तो 5 जजेस का फैसला है, दूसरी तरफ 4 ही हैं. So have a look at Article 145. It talks about rules of courts. I've highlighted the important part. It talks about couple of important pointers, like it says that Supreme Court may from time to time with the approval of President make rules for regulating generally the practice and procedure of the court, including rules as to person practicing, कौन कोर्ट में आ सकता है, हियरिंग कैसे होगी. सुप्रीम कोर्ट खुद ही अपने डे टू डे रूल्स बनाता है. क्लॉज 3 says minimum number of judges for the purpose of deciding any case involving a substantial question of law regarding interpretation of this constitution shall be 5. So constitutional bench इसीलिए minimum 5 judges का होता है, 5 or more judges in odd numbers, right? So if you want to overrule a 5 judge bench judgment, you will create a 7 judge bench. अगर 7 judge bench judgment को overrule करना है, you will refer it to a 9 judge bench. Well, clause 5 says that no judgment, no such opinion shall be delivered by the Supreme Court, save, let me accept, with the concurrence of a majority of the judges present at the hearing of the case. So, court का फैसला तभी माना जाता है जब majority decide करती है. So, a 7 judge bench can only decide a matter if 4 judges agree on something. 9 judge bench can only decide if 5 judges agree on something. And therefore, if you read clause 5, it gives us clear answer to this pending question that majority judgment of a bigger bench, larger bench shall prevail. चलिए, next important issue that everybody should be aware of is regarding in re framing guidelines regarding potential mitigating circumstances to be considered while imposing death sentence. Let me give you a brief background of this story. Recently, Supreme Court took up a matter. In re means when they take up suo motu matters, something of great importance. So they were deciding whether same day death penalty can be awarded. So देखिए, जब भी कोर्ट में फैसला आता है, कोर्ट सिर्फ वर्डिक्ट बताता है whether someone is guilty or not guilty. Till that time, your antecedents, your past conduct will not be considered. But once a verdict has been delivered and you have been found guilty, then there will be another hearing in which all the aggravating and mitigating circumstances will be discussed. If you have been a habitual offender, if you are a recidivist, then obviously you will be given a harsher form of punishment. If you committed crime under some mitigating circumstances, something which reduce your guilt, then court will take a lenient stand against you, and might be you will be given a lesser punishment. Vishwajit, I didn't get your question. Shri, his bike, can you please try to explain it further? Oh, चलिए आगे चलते हैं. मीनवाइल, सो यहाँ पे सुप्रीम कोर्ट ने ये कहा कि देखिए बचन सिंह केस के जो पुराने गाइडलाइंस हैं वो अभी कंफ्यूजन क्रिएट कर रहे हैं. So just like in every other criminal matter, even when a death penalty is awarded as per the Bachan Singh judgment, it is mandatory for the court to have a separate hearing of the accused before imposing death penalty. So yes, so ये देखा जाता है कि क्या कोई mitigating circumstances थे या नहीं थे, ये सब देखा जाएगा कब verdict आने के बाद, penalty से पहले. So before imposing death penalty, a separate hearing is a must. So this was decided by a landmark case called Bachan Singh. So Supreme Court bench comprising of Justice U. Lalit, Justice Ravindra Bhatt and Sudhanshu Dhulia noted that there were conflicting judgments regarding the grant of hearing to an accused before imposing death sentence to him. 40th Law Commission and Bachan Singh case में तो यही recommend किया गया कि मिलना चाहिए separate hearing. लेकिन इसके बाद में संता सिंह वर्सेस स्टेट ऑफ पंजाब, मुनियप्पन वर्सेस स्टेट ऑफ तमिलनाडु, मलकियत सिंह वर्सेस स्टेट ऑफ पंजाब also stated something similar. Vishwajit has a question. What does suo motu stand for? Suo motu means self motion. Suo is self and motu is motion. Self motion means जो चीज आप खुद से करते हैं, something that you picked up on your own. That means nobody approached the court. Court decided to take up this matter on their own. Therefore, it is called suo motu. I hope that answers Vishwajit. So the importance of a separate hearing on the issue of mandatory imposition of death sentence was reiterated in several other judgments. कोर्ट ने बताया कि बहुत से ऐसे judgments में पहले भी कहा गया और बार-बार कहा गया है कि separate hearing तो होना चाहिए. However, the court found that on reading of these very judgments, cases like Santa Singh, Muniappan and others, there are different conclusions. Same day sentencing did not necessarily fall foul of section 235 clause 2 of CRPC. So अगर आप सेम डे पे भी वो हियरिंग करते हैं, लेट्स से मॉर्निंग में कोर्ट ने वर्डिक्ट दिया गिल्टी और आफ्टरनून में कोर्ट ने सेपरेट हियरिंग दे दिया, सो सेम डे जजमेंट, दैट सेम डे पेनल्टी इंपोज की जा सकती है, सेंटेंसिंग किया जा सकता है. सो दिस इज interpretation based on Santa Singh, Muniappan, Malkiyat Singh and other cases. Whereas Bachan Singh says that once you have decided once you have decided the guilt, then provide a separate hearing and then listen to all the mitigating circumstances and then decide the punishment. So, because there is confusion, let's read up section 235 of CRPC. CRPC is the procedural law on the criminal side in a country. It talks about judgment of acquittal and conviction. Clause 1 says, after hearing arguments and points of law, if any, the judge shall give a judgment in the case. That means judge will have to view arguments and points of law before coming to a conclusion. Clause 2 says, if the accused is convicted, the judge shall, unless he proceeds in accordance with provision of section 360, hear the accused on the question of sentence. That means once someone has been convicted, judge will have to hear him out on the question of sentence. So why shall we not give you highest form of punishment? The person will provide mitigating circumstances and the prosecution will try to provide aggravating circumstances, right? So all the mitigating factors he can put forth, he can bring up, and he should be given fair chance to do that. Chaliye. So the bench noted that all cases where the death penalty is a choice, it is necessary to place mitigating circumstances on record. However, the mitigating circumstances relating to death sentence can be placed on record only after conviction. तो conviction के बाद ही ऐसा हो सकता है, right? पहले नहीं. And therefore, it is necessary to have clarity on granting real and meaningful opportunity of hearing to the accused in such cases. तो इसीलिए 3 judge bench ने अब ये matter 5 judge bench को refer कर दिया. So whenever this 5 judge bench decides, that will become another landmark case for all of us to note down. Right? So as of today, there is slight confusion. बच्चन सिंह जजमेंट जो है स्टेट ऑफ पंजाब वो ये कहता है कि कन्विक्शन के बाद सेपरेट हियरिंग मिलना चाहिए डेथ पेनल्टी के केस में. सेंटेंस डिक्लेयर करने से पहले, बिफोर सेंटेंसिंग, यू विल हियर द पर्सन आउट. ऑल द मिटिगेटिंग सर्कमस्टेंसेस विल बी put forth, will be placed on record. Whereas other cases which were declared later on didn't specifically say. All of them are saying that person should be given right of hearing. A person should be given an opportunity to provide mitigating circumstances, but nowhere it says that this separate hearing should be on some other date. It can be done on the very same day. Because of this confusion, do you think the accused, once he gets convicted, will be able to provide enough mitigating circumstances on the very same day? So, in order to make it meaningful, I believe that this hearing should take place after some time and not on the very same day. Let's see what the Supreme Court will do in the coming weeks. Okay, one more case law that all of you should note down is Bachpan Bachao Andolan versus Union of India. Supreme Court bench of Justice Indira Banerjee and M.M. Sundaresh, they were hearing a petition moved by this NGO called Bachpan Bachao Andolan, and so BBA, Bachpan Bachao Andolan, was seeking directions regarding urgent implementation of safeguards available in child protection legislation. So the new child protection laws, example POCSO, provide some other remedies and other measures which governments needs to implement, but all the state governments have been reluctant in doing so, and therefore this NGO approaches the Supreme Court of India. So recently, when they were hearing this matter, Supreme Court directed the state legal service authorities to form a scheme for empanelment of paralegals in police station. So once this thing comes into action, every police station will have a paralegal. Delhi government is already running a scheme in which they have empaneled paralegals for each and every police station. So Supreme Court said that Delhi's model can be used as a model for other states too. So Delhi State Legal Service Authority scheme shall be used as a model, and within 3 months each state will have to come up with their own scheme. They also directed that the state governments as well as union government will have to pay money for funding this scheme. Well, so during the hearing, counsel appearing for NALSA, that is National Legal Service Authority, pointed out that problem is not about forming policies. All governments will form up policies. Problem is more related to the funding part. So governments are not willing to spend money on this thing. And that is the reason no other state has been able to implement these measures under POCSO. To which Supreme Court responded that states have to form a scheme in 3 months, and states will have to pay, not willing to fund, but they have to fund. So once court has directed, it is no more a matter of choice, and governments will have to shell out money, and legal aid, or you can say paralegal facilities at police station would become a reality soon. So with this note, today's session comes to an end. I hope you guys got to learn something new, and if you want me to cover anything in particular, just leave a comment once this live stream ends. Thank you so much for watching. Don't forget to like, share and subscribe. याद रखिए बांटने से ज्ञान बढ़ता है और साथ में subscribers भी. Thank you so much guys. We'll meet again. Bye.